Lines. Now let's get to our interview with the guest of the day. I'm joined by a senior advocate of Nigeria, S.A.N.I. Akintola, to discuss the sack of Kano State Governor Abba Yusuf by the state's governorship election petitions tribunal. Senior advocate, thank you so much for joining us this evening for some legal perspectives to our judgment. Thank you so much, sir. It is a pleasure.
Thank you for having me.
Right. So the Kano State Election Petitions Tribunal invalidated the victory of NNPP in that state. What will you consider as instructive in the judgment?
Well, in the first place, what happened in Kano yesterday is not novel, was never novel, it's not strange. It has happened before in this country. And if you look at if you listen to the judgments, and look at the reasons behind the judgments, the reasons advanced by the tribunal, you discover that they anchored same on two major planks. One was electoral malpractices in the area of ballot papers that were said to have been manipulated, as many as 160,000, 165,000 or so, that we are said to have been manipulated and that we are neither stamped nor signed, nor bear the stamp of INEC. And that's a very serious offense under the Electoral Act, Section 63 to be precise. And I listened to some commentators stating that, well, in spite of that, the electoral officer still has the right to make such valid. They've forgotten that the following section of the Electoral Act, they limited themselves to Section 63. If they go further, the holistic reading of the Electoral Act, because don't just read a section in isolation of others. The holistic reading of the entire gamut of that chapter of the Electoral Act shows that the tribunal has the overriding supervisory role to play on. So even where the electoral officer confirmed that, well, in spite of the no stamping, no signing of the ballot papers, we want to render same valid. It is the tribunal that has the final say. That is if the tribunal agrees with the electoral officer of INEC in that direction. And in any case, if you look at if you follow the judgment, there was no area where the respondent called any INEC presiding officer to justify the using of such invalid ballot papers as valid. In other words, if it's not valid, it's not valid. For you to rebut that, you need to call the umpire, those who conducted the election, if you are the electoral officer, and there was nothing before the tribunal that shows that the respondent here, that is the respondent in the election petition in Kano State, call any INEC officer to rebut the allegation made by the petitioner. So the election tribunal has the final say over it. And it is not new. I was privileged to lead a team that did the first of its kind in this country. That's Noshi Omole against Osumbo. That was exactly what we did. Ballot papers that were neither stamped nor signed, or those that were stamped but not signed, they were separated. And of course, I listened to the official of Kano State government in the morning saying, well, if that was done, why was it that it's tenured to the benefit of the petitioners? No. When votes are said to be invalid and they are deducted from the main figure, it inures only to the advantage of the petitioner. The respondent in this case will be at a disadvantage. In other words, if it was decided that 10,000 votes be deducted from your votes, everybody loses. in that direction because it was something that is not peculiar to a particular kind. All the candidates involved in the election, because victim of such manipulation and electoral malpractices. So there is nothing special or novel about it that has not been done before. It has been done before in this country, and of course, many other petitions have followed suit. So it's not strange.
All right. I mean, so since this judgment was delivered, there have been several arguments, and one of them is that it's strange for a popular candidate to win the election and lose at the tribunal. How will you react to that?
Well, my first reaction to that is that the media and those in the social media, the main media and those in the social media, should please allow the judiciary to do their job. Judges should not be intimidated. They should not be commanded. They should, if you know better than they, go to the law school and be qualified and be appointed a judge. You can't just sit out there because may that day never come when judgments will be based on public sentiment, emotion, feelings, or what have you. Our judicial system is equitarian. It is justice according to the law of the land, not justice according to how you feel or your emotion or public morality. In any case, morality is an unruly horse. It takes you to where you don't expect. It's an unruly horse. What is morally reprehensible in one part of the country is accepted in another part of the country. So it's not something that you can put in a straight jacket and say, no, because people are saying it. In any case, who are those people who are saying it? When was the census conducted? Because I'm not always at sea by people making generalized statements. People are thinking, who are those people? You see, our judiciary is becoming too media-driven in this country. And it's not done anywhere in the world. I mean, we have the opportunity of traversing the length and breadth of all the continents of the world, and we've interacted about people who practice in some other jurisdictions, and we've seen that nowhere is what's happening in Nigeria is happening. We are driving the judges. Can you imagine people threatening judges, showing the picture of their children? Even a commissioner in Kano State granted an interview, threatening the judges, even before the judgment was given. So I'm not at home with people who are insulating what we have just said. To me, judges should be allowed to do their jobs, and they should not be intimidated.
Right. So there was this part of the judgment where the tribunal said INEC shouldn't have declared Governor Yusuf winner of the election. What does this say about the election?
You get that question?
Right. There was this part of the judgment where the tribunal said INEC shouldn't have declared Governor Yusuf winner of the election. So I'm asking, what does this say about the entire process?
Well, the judges of the tribunal had the facts before them. They were there. You and I were not there. And again, when people make comments, generalized statement on a particular judgment, without reading the pleadings of the parties, cases are won and lost on the basis of the pleadings. And it is the foundation of the case. As a matter of fact, the judiciary has been so, lenient with litigants in election petition in this country. Because stricto sensu, if the law is to be applied strictly on the basis of pleadings, many petitions will not go beyond the day of mentioning, because many of them don't even stand the chances of any success in the first place. But because our people assume the role, the public, the so-called public, assume the role of know it all, quote and unquote, you and I have no power to decide for the judges. They have the facts. They know the circumstances. They listen to the witnesses. They look at the manuals. And all these other things that are associated with litigation are before the judges. So it is not open to an outsider who knows little or nothing. Because you see people coming over to comment on what they know little or nothing about. It should not be. The judges are the one trained in the area of laws. They understand the Electoral Act. They know what the conscience is. It's not about emotion. It's not about your feelings. Like I did say, may that day never come when judgment of our cause will be based on sentiment, morality, feelings, or what have you.
So again, senior advocates, looking at the numbers, 165,663 votes were deducted from the NNPP. What's your opinion about this? Some people feel deduction shouldn't be the case here.
Well, like I did say, what happened in Kano was not new. It was not strange. It was not new. It happened in Oshie Umale's case against Osumbo. And as a matter of fact, that was the first time a sitting government was removed through the judicial system in this country. And I was privileged to be the lead counsel there that led the team. So it was something that was novel then that was done. And in any case, people are getting wiser every day. Many petitioners, lawyers go the whole hog to do their own work, to look at the pleadings of their opponents and make the same. But if you sleep on your bed the way you prepare it, and people have to appreciate that cases are won and lost in chambers. Not in the court. You have lost the case before you leave your chambers through your pleadings. As a matter of fact, like I did say, the judiciary has been so lenient these days in the case of election petition. They've been so liberal because in ordinary cases, you are even on the first day, you'll be asked to address. Look, counsel, can you address? Look at paragraph 25 of your pleadings. Can you address us on that? Vis-a-vis your claim, your release. If you are saying, for instance, like we had in one of the cases, I don't want to mention that where somebody was claiming that he won the election in the entire country, and he said he had 40,000 in his own plea. He said he had 40,000 polling agents, which is submitted to INEC, because you will have submitted that ahead before the election. But when you look at the demography of election in Nigeria, we are having 176,602 thereabouts polling units in this country. Now you look at 40,000 polling units of the petitioner. What is the percentage? Vis-a-vis 176,000. In other words, a petition ought to have been dismissed on the first day of mentioning the case. Doesn't stand the chance of any success. But because of sentiment, because of social media and all the noise, you see, Tribunal still bent backward to hear everything out, to hear him out. You see, what me met when I joined the profession, close to 4 decades now, it was, if you on the basis of your pleading, sometimes you are sent out of the court. Your cases are thrown out.
But senior advocate, how worrisome is it that the deducted votes were neither stamped nor signed, and the election was considered conclusive?
Probably a mistake on the side of INEC, and unfortunately, the petitioner will not suffer them gladly, because INEC itself was a respondent in the petition. The question is, what was their response to the petition? Were they able to defend that? What was the response of the respondent vis-a-vis defending the petition? Because INEC conducted the petition. And if you are saying, look, what you conducted, what you declared, 165,000 of the votes were invalid. And if it's invalid, it's invalid. You cannot even agree to do illegality, even if there is any agreement, because somebody was saying today that after all, the man who contested as the governor was not complaining and even congratulated the winner. They've forgotten that no one is allowed under our law to make agreement or to agree on illegality. The mere fact that your daughter, who's a minor, is not complaining that you have carnal knowledge of her, doesn't absolve you of the criminal charge of rape. So in other words, whether you agree to the commitment of the crime or not, the law will still take its course. And we must appreciate the fact that it's not just the candidate that's contesting the election, even the party too is contesting the election. So if the party is a petitioner, can you deprive the party who sponsored that candidate its right to contest the election that was said to be invalid? No. Both the candidate and the party have the right to challenge any election said to have been conducted outside the purview of the Electoral Act and the Constitution of the Federal Republic of Nigeria. So, to that extent, that votes were deducted like this, it was not new. If the votes are invalid, they are invalid. No one can make such votes valid by mere wishful thinking or feeling, no.
Right. So, senior advocates, we'll definitely come back to this issue of APC governorship candidate conceding defeat. But then, in all of this situation, what's the place of the Beavers and IREF?
I beg your pardon?
What's the place of Beavers and IREF in this?
Oh, Beavers. You see, people
right.
have been
and
making
IREF.
mistakes. Beavers and IREF.
Absolutely.
And this Apex Court of the Land had made pronouncement on that in the case of Adeleke against Oyetola. And that is it. When the Supreme Court made pronouncement on an issue, that is final. It is the Apex Court of this land. It's only the same Supreme Court that can change its position. Not by wishful thinking, not by anybody's whims and caprices. No. The Supreme Court has said, and rightly so too, that the Electoral Act never made Beavers and IREF sine qua non. People have been reading section 64, 65, upside down. You have to read the entire, the canon of interpretation, especially of the Constitution, of such crucial, of such importance, demands that you read the entire sections of the Electoral Act. You see, but people just key only to what they want to hear. They speak what they want to hear. Like the disco critics, they only listen to themselves. They only listen to others. You see, a careful look at other sections of the same Electoral Act shows clearly that Beavers was never meant to be sine qua non. In fact, INEC has the discretion throughout. And again, people made recourse to INEC guidelines and what have you. My simple answer to that is that there's no time a rule of court to override the statute. It has never happened before. And because most of these people don't read, if they don't read, they will have known that the issue of discretion was long settled as far back as 1947. But that was the first case handled by our referred father, Baba Olowo. So the case of Laguju against Olubadan Council, if it appears to Olubadan Council that Laguju was not fit and proper to become Timofede again, at that time, the entire areas of Ede, Oshogbo, Ejigbo, Ikirun were under Ibadan control. And it was the practice then for the baalies in those cities to aspire to become Magaji in Ibadan. So, Laoye made attempt to become Magaji. He contested against Agbaje, Salami Agbaje. He lost. And he wanted to go back to reclaim his throne in Nede. But in the process of doing that, he was very rude to the Olubadan Council. He could not go back there. And the Chieftaincy Ordinance was very clear that if it appears to Olubadan Council, and it was so interpreted by West African Court of Appeal in Accra, that was when that principle was formulated. If you have a discretion, to give you my wristwatch, without any consideration. If I refuse to give it to you, what can you do? There's no consideration, no contract whatsoever. So in this case, the principle of discretion operates in several cases across this country. And as late as 2011 here, AIC case, the Supreme Court set aside its own rules to follow the law, the statutes. Its own rule, that was the Supreme Court. So people should appreciate, but because most of these people don't read, and they assume that they know more than every other person. And that's where the problem is. And again, I did say, the media, the judiciary is becoming too media-driven. And the judges too are not doing anything about it, because most of the commentators who comment matters that are still pending before the courts have been sent to jail for contempt. A lawyer and his journalist friend were sent to jail by Chief Justice Oyemade, the whole Chief Justice of Nigeria, the Chief Justice of Western State. It's there in our laws. But they close their eyes to it, and they just, so many of the judges are becoming timorous souls, where they should act when the rules of the land or the rules of court have been flouted. They do nothing about it. Even senior lawyers come before television station and radio, and they be commenting on matters that are pending in court. It's not done. It's even unethical. But that's what we're having now. You can comment and scrutinize judgment after it has been given, like we are doing now. But why the matter is still pending? For instance, if this matter is appealed tomorrow, I will not come back here tomorrow to discuss this. The moment the matter is still sub judice or still pending in court, I won't come before any television or radio station to comment on it. It's unethical.
All right, student advocates, let's take a break. I've been speaking with Niyi Akintola, SAN, and tonight we're discussing the sack of Kano State Governor Abba Yusuf. This conversation will return when I come back. Please stay with us. Welcome back to Politics Tonight, and I've been speaking with a senior advocate of Nigeria, SAN, Niyi Akintola. Tonight, we're looking at the legal perspective to the judgment by the Kano State Petition Tribunal. All right, SAN, now let's move on with this conversation, and we will also look at one of the factors surrounding this judgment, and that's the virtual delivery of that judgment. What's your reaction to that, and why did it do that?
Pardon?
I want us to look at one of the factors surrounding that judgment, and that's virtual delivery of that judgment. What's your reaction to that? And why did you think that happened?
No, I understand, madam. I'm at sea. I don't get your question.
I want us to look at the virtual delivery of that judgment. What's your reaction to that, and why did it do that?
Again, that is not strange. Even the rules of the court have been so amended. I, sitting down here, I conducted factual proceedings, even at the Supreme Court, and judgment has been given. What is important is that you are giving the notice that your matter will be coming up on so day. So if you are giving the notice and you don't key into the system, just too bad. If once you are served the process of a court, it is incumbent on you to respond to it. If you are asked, if you are commanded to appear before a court, of whether virtually or physically, you must appear. So there's nothing strange about giving the judgment virtually. In fact, during the COVID, the rules of our court were streamlined along that line to hear matters virtually and to deliver judgment virtually. So it has become part of our legal system now to hear matter virtually and and deliver judgment factually.
Impressive. All right. So, I mean, what's the implication of this for justice delivery in the country?
It enriches our jurisprudence. I mean, it's become part of our judicial system now, and of course, there are two other layers, of course, that the case has to go. So it depends on how their lordship view the judgment. Like I did say, you and I have no power over it. It is within the province of the judges to decide cases before them. And of course, we can only come over to start analyzing it that we are doing after the judgment will have been given, not before. And like I did say, no judge should be threatened for doing this or her job. No judge should be, like the commissioner in Kano State, I understand this is a 31-year-old man, probably too young to appreciate the danger inherent in his comment for it. Because those of us who speak Hausa language, who listen to his threats, shows that clearly a criminal offense has been committed, but he was given soft landing, a slap on the wrist, and it was just relief of his post without more. And I feel that something else should have been done. There should have been consequence for his comments that would teach others a lesson. Because the penal code is very clear on what he did.
All right, so let's come back to this. I know this is something you had mentioned earlier, but for emphasis' sake or better perspective, the APC candidates had earlier conceded defeat after announcement of that result. What lesson can people learn from this?
Again, I come back to the issue at the LR is that our people no longer read. They only sit behind computer or their handset sticking their neck out to social media. That was done before in this country. Governor Fayemi congratulated his rival when he lost the second-term ticket to Fayoshe. And he still went to the tribunal after that. It's a constitutional right of the petitioner to so do. The mere fact that I say congratulations to you for slapping me does not stop me from reporting you to the police that you have assaulted me. Or that I looked the other way after slapping me and I just went to my house to speak. That shouldn't stop me if I should decide to report you to the law enforcement agencies. So that you have congratulated somebody doesn't deprive you of the right given to you by statutes and the Constitution.
But senior advocates, it is said that votes belong to political parties. But what happens in a situation when a candidate opted out of litigation and the party wants to pursue such?
It doesn't affect the party. The party too contested the election. In fact, in the past, it was said in Amechi's case that it was the party that contested the election and not the candidates. But these days, candidates now have been brought in. So don't forget that our Electoral Act has gone through a series of surgical operations, some induced by judicial pronouncements, and some by the whims and caprices of some people. That's why we are all saying that we should go back to the Waste report and adopt that. But that was an holistic approach to electoral issues in this country. But the powers that be have not deemed it necessary to adopt the Waste report.
All right, but let's turn it the other way. What if it's a case where the party opts out and the candidate wants to pursue such? What happens in that situation?
It happened in Muhammadu Buhari's case. NPP pull out of the petition, and Muhammadu Buhari was still given the right to proceed.
Right. So the tribunal declared. Okay. Please go on.
I mean, the political party and the candidates have their I mean, have their interests tied together, joint and several. In other words, either of them could maintain petitions.
All right. So, I mean, the tribunal declared APC candidates.
In Kano that it was not part of the case. The mere fact that he kept quiet doesn't mean that he was not party to it. And the mere fact that he congratulated the winner doesn't mean that he had no right to enforce.
All right.
On a very firm ground, if he so decide, he can still enforce his rights.
Right. So
it is even a constitutional right, which no one can take away from him.
all right. So the tribunal declared APC candidate Nasir Gawuna as the winner, but it's still a long way in this race. How he advised both parties to conduct themselves, SAN?
Well, the parties have their lawyers, and their lawyers are the masters of the game. They know what to do in the circumstances. And the party that lost knows that it's time to do the needful. Start counting since yesterday. See, it's now included the day of the judgment. They know what to do, and it is time bad.
Right.
They are the masters of the game, so they know what to do in the circumstances.
Right, but as we speak, Governor Yusuf has instructed his legal team to appeal these judgments, saying it was marred by human imperfections and...
It is his constitutional right to do.
I guess...
He has two other layers to play with. So...
Right. So, SAN, I was saying the governor has instructed his legal team to appeal this judgment, saying it was marred by human imperfections and misapplication of the law. So how will you react to this?
Well, I must commend the governor whose election was declared invalid. I read his statement. It was very, very civil, very, very commendable. It was a statement that speak about peace without necessarily hitting up the politics in Kano State. And we have to commend him. He's a statesman. We have to commend him. Unlike his commissioner, who was being facilious and perhaps because of youthful experience, because I understand he's a 31-year-old man.
Well, is it good to say... do you think, is it good to say that there was a misapplication of law?
That is his own opinion. He's not the judge. He should wait. When he gets to the Court of Appeal, their lordships who are trained in that aspect of our profession, they know what to do. They know what to do. So we should allow the judges to do their job for crying out loud. Like I did say, our judiciary is being too media-driven. And I wish the governor will file his appeal timelessly so that people will stop commenting on this, throwing up all sorts of insinuations, half-truths, and what have you. Because when the appeal is filed and served, everybody should keep quiet and allow the law to take its course until final determination of the case.
Right. SAN, with all of these recent tribunal judgments, many have said INEC deserves some knocks. Do you agree? And if you do, where did you think INEC erred?
Well, INEC is being manned by human beings, and there are rooms for mistakes. And that was why the Electoral Act talk about substantial compliance. Not that everything will be complied with. And if there are mistakes here and there, because this is the first time I'm reading that there were still ballot papers that were unstamped, unsigned, and what are authenticated. There are 36 states in this country, and there are election petitions in virtually all the states of the Federation, except those states where elections were not conducted. So, if we have just one isolated case of such, I think we should give INEC its due. Give INEC its due.
Right. I'm asking these questions because we have elections coming up in November. Where do you think INEC needs to tighten its belts?
We teach INEC a lesson. They will be better prepared for those elections coming up in November. They will ensure that all the ballot papers complied with the provision of the Electoral Act. That will bear the stamp and the authentication of INEC. And you see, regardless of, no one should rely on the provision of Section 63, Subsection 2, that says where the presiding officer or the electoral can still say, okay, I allow you to go. Because the tribunal is waiting for him or her. The tribunal has supervisory role over his discretion. And the tribunal has a duty to perform. Unlike his own, he has a discretion. For the often time, we are saying it. A discretion is not a law. It's not sine qua non. It's not something that is cast in iron or a rocket sign. No. It's a discretion. You can do it. Maybe you have to do it. But when you have a mandatory section of the law that says you shall do this, you don't have a discretion. But to do it.
Right. So, SEN, still, in the last few days, I've spoken with few persons who have been very insistent on the fact that our Electoral Act still needs to be reviewed. Is this a fact?
Well, there are rooms for improvement. There are rooms for improvement. My only advice to the National Assembly is that if we have another opportunity to tinker with the Electoral Act, they should call in the practitioners to guide them. You see, law is a science. This is not something you do on emotion, and you don't make a law targeted at a certain class of people, like the National Assembly tried last time and shot itself in the foot. Practically excluding itself from the list of the, because they had the governors in mind and they felt they would deal with the governors. But in the process, they dealt with themselves. So a law is said to be a law when it is certain, when it is universal, when it is non-discriminatory. But when you are making a law or do an amendment that discriminates against one section of the country, it will fail. So when next they want to tinker with the Electoral Act, they should call in those who are knowledgeable in that areas of laws. It's not every lawyer that can speak or address the issues of the Electoral Act. I'm very sorry to say this. With due respect. Yeah.
All right. So before we move on to other issues, SAN, our elections continue to be determined by court. What's the implication of this for the country's democracy? Why should courts have the final say?
I beg your pardon?
Right. So in the last few years, our democracy, or rather our elections, continue to be determined by court. What's the implication of this for the country's democracy? And why should courts have the final say?
You see, we are still growing. And that was why I stated earlier on that we should allow the judiciary to do its job. The judiciary should not be intimidated or blackmailed the way we are doing. You see, judiciary determining the fate of election petition is not peculiar to Nigeria. That is the situation in all civilized countries, including the United States. The difference between those claims and ours is that we have not done enough thinking on our electoral system. The last time we did was through Uwe's panel. We did a very good job. But the power that be threw away the most important aspect of that report, threw it into the dustbin. See, for me, speaking personally, I don't see the reason why an objection that is so fundamental that has been raised against a particular petition should be allowed to waste the resources of the, should be allowed to be in the cooler for some time to say, look, let's finish the substantive matter before deciding the case. If an objection is so fundamental that will determine the fate of the petition, especially if it is based on pleadings, you can't put something on nothing. Like I did say, I've seen petitions that ordinarily should not last more than 2 days. On the day of their mention, that was the way we were trained. Cases are won and lost on the basis of your pleadings. If your pleading is so frivolous that cannot even sustain your relief, why keep it such in the docket? So petition ought to have been thrown out because so many other cases are waiting to be attended to. But as we are now, Judiciary is so overwhelmed. So many other cases are lying fallow in various courts of the land that has not been heard because judges are all over the country doing election petitions. So that's my grounds. These are the things we should take into consideration. We should factor that in when we are making another amendment. Certainly, it's a work in progress. It's not something that you can put in the stranger to know we are completed the exercise. No, we still need to think out the Electoral Act.
Right. All right. So before I let you go, let's move away from the court and the law. Let's talk about the economy. How will you describe the way the approach of President Tinubu to reviving the economy? Essian, did you get my question? How will you describe the approach of President Tinubu to reviving the economy?
Well, so far so good. Give it to him. This is a man who knew his honors. He had his just well cut out for him from the word go. Of course, what he meant on ground was terrible. But for him, telling us not to pity him, I would have said he should be pitied. You see, because look at the state of our economy. Look at what he meant on ground. Look at the state of our indebtedness to various organizations and countries, including China. See what we are owing. Don't forget that was to the credit of our Obasanjo that he cleared the Paris debt and did so many other things to stabilize the economy. But over the years, we have piled up so much debt, and all of us have been living beyond our means, including you and I. That's the bitter truth, but we won't want to accept that. A man on 50,000 naira that earns 50,000 naira and want to ride a car, how will we be able to manage such? When I joined the legacy as a youth, I started with B2. Many people of our generation started with B2 on hire purchase. We live in face me, I face you, which people call face me, I slap you now. So we've been living beyond our means. People who should ordinarily not be riding one car will be riding two. And I tell you, if you want to hear the truth, our fuel, PMS, is the cheapest across the globe, or one of the cheapest, truth to say. Because I know that as we speak in the US, even in Texas that produces oil, that are not producing seed, a liter of petrol is $1.5. Translate that into Naira. I mean, sorry, $2.4. Translate that into Naira. And the UK is 1.5, 1.4, depending on the areas where you are buying where you are filling up your tank. It's because everything has been deregulated there. But in our own case, we just decided over the years to be enriching some few elements.
Thank you so much, SAN.
Who are not.
Thank you very much. We're out of time. Thank you so much. I've been speaking with Senior Advocate of Nigeria, SAN Akintola. Thank you so much for helping us with some legal perspectives on the program tonight. Thank you so much, sir. Thank you.
Thank you for having me. And once again, the media should let off the hook on the neck of the judiciary. Let the judiciary also work. You have been encouraging those elements in our society that are not doing anything good to the system.
SAN, is it the media or the politicians?
Them on the television. You see, the media should stop encouraging such people. They should be ignored.
SAN, is it the media or the politicians? You're blaming the media. Is it the media or the politicians?
Of course, because the media has been encouraging that. I'm not saying that it is the media. As a matter of fact, the media has been doing a very good job because without the media, we wouldn't be having this democracy. I was on the street.
All right. Thank you so much, sir.
I was a member of NADECO. But what I'm saying is that when we see people doing something that is against the interest of the country, we should not encourage them.
We're doing our best. Thank you, SN.
Once again, thank you for having me.
And thank you very much for watching. That marks the end of today's episode of Politics Tonight. But the conversation continues from here. Get in touch with us on X, formerly Twitter, at TVC News NG, and at Olajumoke using the hashtag Politics Tonight. We're also on YouTube at youtube.com/TVC News Nigeria. I am Olajumoke Olatuji. See you tomorrow.